With that being said, I would now like to introduce our presenter today, Scott Newman. Scott has been a criminal defense lawyer in Manitoba for 17 years. After graduating as class valedictorian at Robson Hall Law School at the University of Manitoba, he worked and articled for legendary lawyer Greg Brodsky, KC, for 3 years. Scott has appeared at all levels of court in Manitoba and while also appearing in courts in Saskatchewan and Ontario. He has been a board member of the Criminal Defense Lawyers Association of Manitoba for 15 years. We are so pleased to have him here today to share his expertise. And without any further ado, I will pass it over to Scott. Thank you so much.
Thanks very much, Nina, and thanks very much to everyone else for coming out to hear a little bit of a speech or a little talk about the Canadian Charter of Rights. I'm going to share my PowerPoint that I've prepared so that everyone can hopefully follow along. And is everyone able to see that PowerPoint?
Looks good.
Looks good. Thank you for that. So I will simply start, I think, by thanking the Community Legal Education Association for hosting this and putting on presentations like this. I understand this is part of their Access to Justice series. The Supreme Court has, and most of the cases that I'll be referring to today are Supreme Court of Canada decisions. The Supreme Court of Canada has clearly come out and said you cannot have rule of law without access to justice. Otherwise, as quoted in the Council of Canadians with Disabilities from just 2 years ago, otherwise the rule of law is replaced by the rule of men and women who decide who shall and who shall not have access to justice. And some of the concepts that underpin access to justice, some of the things that we look to when determining whether or not access of justice is available, is individuals knowing what their rights are, understanding how the legal system works, being able to secure legal assistance, whether that's from lawyers, whether that's from paralegals or from organizations like CLIA, knowing what your legal remedies are. If something is done to you that's wrong, what can you do about it? And breaking down barriers that prevent individuals from accessing courts, accessing remedies. So proceedings like this are very important to encouraging that access to justice. What we're going to do today in terms of this presentation is just take what I've termed a historical walking tour of the Charter. We're going to start by discussing the development of the Canadian Charter of Rights and Freedoms, which is obviously the primary constitutional document by which the rights of Canadian citizens are outlined. Things that influenced how the Charter was developed, the wording that was used, and how courts interpret the rights contained within the Charter, and how they've influenced its interpretation. Once we've reviewed the basics of Charter development, we're going to go through some of the individual rights, just a few of them, that are listed in the Charter, the ones that are usually come up in criminal litigation, what they mean and how far those protections go. As I've said, the Canadian Charter of Rights and Freedoms is part of the Constitution of Canada. And when you think about what a constitution is, it's obviously the supreme law of the land. All other laws that are passed by either Parliament or by a provincial legislature, such as the Manitoba legislature in Winnipeg, have to conform to the Charter because of that supremacy. This is the supreme law. All other laws must conform to it. And prior to the enactment of the Charter in 1982, when it was brought home to Canada from the United Kingdom and agreed to by most of the provinces, there had been no specific written constitutional documents in Canada that placed significant limits on government powers with respect to individuals. There were obviously some documents, some ancient documents that are part of the constitutional tradition of Canada, such as the Magna Carta, but nothing Canadian, nothing that had the kind of specificity that I think a lot of us think of when we think of constitutional protections. And you can see I've talked here a little bit about how Canada has that common law tradition. That means inherited rights that we receive through either case law, through decisions of judges, that we receive from the Magna Carta, that protect us from the government. And these, while significant, were limited in many ways. For example, it was always accepted prior to the advent of the Charter that the rule of law was supreme, that no person is above the law, no one can be imprisoned or jailed without having done something wrong, without having broken the law, and that courts are impartial and courts will decide contested issues between different parties or between the government and an individual. It was always accepted, for instance, that people charged with serious offenses had the right to a trial by jury. These are examples of some specific rights that Canadians had prior to the advent of the Charter in 1982. But you can see that there's quite a limitation on it. And that limitation, that gap in the law was quite evident by the time 1982 rolled around. There's no explicit listing of the limitations on government power, no specific protections for individuals. And of course, we live directly next door to the United States, where they have very significant written protections through the Bill of Rights, through their various amendments for protections from the government. When you think of the 1960s, and the reason we're talking about the 1960s is because something significant happens there. World War II was still very fresh in everyone's memories, having been just a decade past, where there was very significant concern about totalitarian governments, belligerent governments, fascist and repressive governments, where individuals had been specifically targeted by governments for their personal characteristics. And I've included, for instance, groups like Jews, Catholics, trade unionists, homosexuals. Obviously, there were issues with respect to prisoners of war, many other individual characteristics that resulted in repression by very severe governments. And this was something that was very much top of mind for people in the post-war period, to the point that at the end of World War II, the United Nations, when it was perhaps maybe a little more effective than it was now, drafted and passed what's called the Universal Declaration of Human Rights in 1948. This guaranteed a number of different rights to individuals, and most of the governments of the world signed on to that document. It was also a period of time going into the 1950s where there was a period of significant social progress in the United States. There were a number of different Supreme Court decisions based on the Bill of Rights, which ruled on things like racial equality, segregation of institutions, voting rights, and other protection from government. For example, Brown and Board of Education, which led to the desegregation of schools, was a 1954 decision. So you have this big movement towards social progress post World War II, in 1948, because of the United Nations, and through the 1950s, and that influence comes to Canada. And in 1960, Canada passes what's called the Canadian Bill of Rights. It was brought forward by Prime Minister John Diefenbaker, who was conservative. He was an individual who had practiced as a criminal defense lawyer prior to and during his service as an MP. And through his work, and both as an MP and as a lawyer, he recognized the gap in protections for Canadians with respect to government power. And this was a bill, the Canadian Bill of Rights, that passed through with the goal of limiting that power of the state with respect to individuals. John Diefenbaker actually came to Winnipeg in 1973 and gave a speech to the Manitoba Law School Foundation lecture. And these are the words that he gave as recorded in the Manitoba Law Journal of 1973. And he quotes as follows: The popular emergence of the phrase human rights had its modern beginnings in 1945 in San Francisco at the United Nations. I was there in a very humble capacity. The Free Nations meeting there determined that they would establish a system of international rights that would collectively embrace the whole series of individual claims and protections. Their concepts were set out in the Charter of the United Nations. It was followed by the Universal Declaration of Human Rights in 1948, by the Covenants on Civil and Political Rights, and in 1965 by the Convention on Racial Discrimination. San Francisco brought about new hopes for peace for all mankind, of a world in which nations would agree to abide by standard of fairness and equality for all. He goes on to say, its principles were not new. They were based on generations of law, religion, and philosophic thought, and were in harmony with our Judaic and Christian traditions. The Old and New Testaments, Plato, Aristotle, St. Thomas, Maimonides, contributed to modern concepts of human dignity and human freedom. The institutions we inherited having to do with human rights ring of British history. Magna Carta, the Crown and Parliament, the Crown in Parliament, the Common Law, the Petition of Right, the Bill of Rights, habeas corpus, and above all, the impartiality of the judiciary. A decade after Confederation, Mr. Justice Taschereau of the Supreme Court of Canada, in speaking of the Canadian heritage of freedom, said, "We have borrowed from English institutions which, with regard to civil and religious liberty, leave to Canadians nothing to envy in other countries." So even John Diefenbaker believed that much of the work protecting Canadians against government overreach were inherited and sorted out in good stead through the Bill of Rights in 1960. And it's not surprising that he would be proud of the work that he had done, but even after 1960, it was still obvious to many that the Bill of Rights was not going to solve the problems that it was hoped. And there were two very big problems with respect to the Bill of Rights that was passed in 1960. The first problem is that it wasn't a constitutional document. It was passed by the federal government only, and since it was only a federal law, it could not be used to protect any rights that were infringed by provincial governments. Its protections were limited only to laws and actions of the federal government, which for the most part in the day-to-day lifestyle of people is not going to be their primary area where they come into contact with the law. Policing is provincial. Healthcare is administered provincially. You're dealing with municipal governments if you have anything to do with your home or with taxation. So the vast majority of the contact that individuals have day to day is with the provincial government, and this is a document that was just too limited in scope to have those protections. The second problem was that, as I said, it's not a constitutional document. It was just a regular statute. It was just a regular law, even though it was called the Bill of Rights. And it didn't go through the procedure that was required to give it constitutional scope. And since it didn't have the supremacy that we talked about in terms of constitutional documents, it couldn't overrule other laws. The general expectation with respect to rule of law and with respect to governments is that one government cannot bind the hands of a future government. I can't pass a law today that says for the next 100 years, future parliaments can't pass the following laws. Every new government that comes in has been voted in by the people of that day. And so it's only constitutional documents that are approved to last forever that have that level of supremacy. And the Bill of Rights did not have that. And it did not have the ability to overrule other laws. So in 1982, the Charter of Rights comes to Canada. It goes through the constitutional process. It receives, it passes through the majority of the provinces, passes through the House of Lords and the House of Commons in England. It's signed by the Queen, and the Constitution comes home to Canada. We're no longer bound by United Kingdom constitutional law. And once that constitutional document is passed, the task then fell to judges in the judiciary to begin to interpret a brand new constitution, one that's never been contemplated before, as to what it means, how large it is in scope, and what its protections are. Now, there are a number of different ways in which you can interpret constitutional documents, and we know that one of those methods that's come into vogue in the United States is called originalism, which is really talking about the meaning of the Constitution is fixed in time. You can only rely on it insofar as we look at it through the lens of the people who passed it. So when American originalists are interpreting the US Constitution, they're saying, what did the people of 1788 and 1792 think about what this Constitution meant? This form of interpretation is one that encourages judicial restraint, meaning that you can't overrule laws just because you don't like them. But what that also means is that you're somewhat hidebound. It also means that when times change, people in 1788 couldn't imagine a computer. They couldn't even have imagined airplanes. Or machine guns that can shoot hundreds of rounds a minute, when they're saying you have the right to bear arms, and they're thinking about muskets that are inaccurate and take 6 minutes to load. So that is one potential form of constitutional interpretation. It's one that's been specifically rejected in Canada. And in one of the earliest decisions interpreting the new Constitution in 1984, the Supreme Court of Canada adopted what's called the living tree doctrine in a decision called Hunter and Southam, which was about a search warrant of a media business. And Justice Dixon wrote in Hunter and Southam as follows: "The need for a broad perspective in approaching constitutional documents is a familiar theme in Canadian constitutional jurisprudence. It is contained in Viscount Sankey's classic formulation in Edwards and Attorney General for Canada from 1930. And the quote from Viscount Sankey of the House of Lords in 1930, the House of Lords was deciding the law of Canada. He quotes as follows: "The British North America Act planted in Canada a living tree, capable of growth and expansion within its natural limits. The object of the act was to grant a constitution to Canada. Their lordships do not conceive it to be the duty of this board. It is certainly not their desire to cut down the provisions of the act by a narrow and technical instruction, but rather to give it a large and liberal interpretation." So this is the foundational line of reasoning for interpreting the Charter of Rights and Freedoms that's been adopted in Canada, is this idea that it's meant to be interpreted largely and liberally, to think about what are we doing with these rights. We don't want to construe them narrowly and say that they're only to a small number of things. They apply broadly. And you can see that Justice Dixon is talking about the need for a broad perspective. He's talking about looking at the context of any given situation to determine whether or not the charter rights apply, and if so, how. But the context of the situation of any given interaction is important in making that determination. He goes on to say, "I begin with the obvious. The Canadian Charter of Rights and Freedoms is a purposive document. Its purpose, the purpose of the Canadian Charter of Rights and Freedoms, is to guarantee and to protect within the limits of reason the enjoyment of the rights and freedoms it enshrines. It is intended to constrain governmental action inconsistent with those rights and freedoms. It is not in itself an authorization for governmental action. In the present case, this means, as Proust J. pointed out, that in guaranteeing the right to be secure from unreasonable searches and seizures, Section 8, which is the section dealing with unreasonable search and seizure, we'll come to that in a bit, Section 8 acts as a limitation on whatever powers of search and seizure the federal, provincial governments already and otherwise possess. It does not in itself confer any powers, even of reasonable search and seizure, on these governments. So what Justice Dixon says in this phrasing is that you have to look at the purpose of under any right. And this purposive or purposive analysis is the foundation of all charter litigation and analysis. You always start with the point, what does this right mean to protect? What is its reason for being? And once you understand the reason for the right, the reason it exists, then you can look to the governmental action and see whether it needs to be constrained or not. But that context, that purposive analysis, is the basis for all charter analysis. And you can see I've sort of talked about this. We're not looking at a narrow and technical interpretation of the charter right. We're looking at a large and liberal interpretation meant to change and grow with society and with technology. When society's viewpoints change, and that is recognized that viewpoints change over time. And, you know, once upon a time, the Canadian government thought it was fit to refuse entry to the government from people of Sikh background, people who were fleeing persecution in Europe, fleeing the Nazis. Those viewpoints today would be repugnant. And this recognition says you're meant to adapt with the times when you're doing charter analysis. And it's also quite clear this is meant to protect rights of individuals and rights of groups. The government gets no new powers out of the Canadian Charter of Rights and Freedoms. It is a constraining document. I've also put in a quote here from Big M Drug Mart, sort of talking again about that contextual analysis. Again, 1985, a very early decision. Again, a decision of Justice Brian Dixon, who was very much involved in many of these early decisions. The purpose of the right or freedom in question is to be sought by reference to the character of the larger objects of the Charter itself, to the language chosen to articulate the specific right or freedom, to the historical origins of the concepts enshrined, and where applicable, to the meaning and purpose of the other specific rights and freedoms with which it is associated within the text of the Charter. The interpretation should be, as the judgment in Southam emphasizes, a generous rather than a legalistic one, aimed at fulfilling the purpose of the guarantee and securing for individuals the full benefit of the Charter's protection. At the same time, it is important not to overshoot the actual purpose of the right or freedom in question, but to recall that the Charter was not enacted in a vacuum and therefore must be placed in its proper linguistic, philosophic, and historical contexts. So again, this is talking about you're trying to determine the purpose of the right when you're looking at any particular interaction. Look to the history of the origins of the concepts in the Charter. Why do we have protections against unreasonable search and seizure? Why do we have the right to speak to a lawyer upon arrest? What are the reasons that these concepts developed over hundreds of years? Look to the language chosen to articulate Section 8, Section 9. What's the specific about the wording? Character and larger objects of the Charter, that it's a constraining document that's meant to be interpreted largely and liberally. But he reminds us again, you don't want to overshoot the actual purpose. You have to look at all of the context of the right and of the interaction, the challenged government action in order to determine whether a right has been infringed. And that has become the basis for all Charter interpretation. Once you know what the right is meant to protect, once you know the purpose of the right, you can then look to the interaction, the challenged law, and decide, is there an actual conflict? Does this actually infringe someone's rights? Is the right limited in some way that doesn't include this? So I've included here what I would say the four main sections that generally come up in criminal litigation with respect to the Canadian Charter. Section 7, everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof. except in accordance with the principles of fundamental justice. You then have Section 8. Everyone has the right to be secure against unreasonable search and seizure. Section 9. Everyone has the right to be secure against, oh, I've written the same one twice. Everyone has the right not to be arbitrarily detained or imprisoned. So that's what that one should say, not to be arbitrarily detained or imprisoned. And Section 10B, everyone has the right on arrest or detention to retain and instruct counsel without delay and to be informed of that right. So those are the four main sections that generally come up. It's often been said that Section 7 is a type of general overarching clause that's sort of the mother clause that is the basic right, and everything else after that, Section 8, 9, 10, 11, 12, 13, 14 are all specific examples of or subsets of Section 7, that these are types of principles of fundamental justice. So we're going to go through each of these sections one at a time, talk about what the rights mean, how they're protected, and look at a couple of cases and examples about how they've been interpreted. Section 7, as I said, you have the right to life, liberty, and security of the person, and the right not to be deprived thereof, except for in accordance with the principles of fundamental justice. Here's what the Bill of Rights has to say, 1791. No person shall be deprived of life, liberty, or property without due process of law. The 1948 United Nations Declaration on Human Rights. Everyone has the right to life, liberty, and security of the person. You can see how those two documents have influenced the Canadian Charter and the Bill of Rights in 1960. In Canada, there have existed and shall continue to exist the following human rights and fundamental freedoms, namely the right of the individual to life, liberty, and security of the person, and the enjoyment of property, and the right not to be deprived thereof except by due process of law. You can see that in the US and Canadian Bill of Rights, property was specifically protected, and the Charter does not protect property. It only protects individuals. So property is something that has been specifically excluded from Section 7. But I hope this gives you a picture of seeing how these fundamental documents have influenced the development of the Canadian Constitution. So talking about that purposive analysis, what is the purpose of Section 7? This is obviously very broad language. You can all, I think of many types of laws which impact either life, liberty, or security of the person. Certainly it includes detention by police, imprisonment. Their immigration issues can be affected by Section 7. Anything that involves health, there's a number of cases dealing with the healthcare systems that impact and interfere with Section 7. You can see that the language in previous iterations talking about due process of law has been replaced with principles of fundamental justice. Does that make a difference, or is that simply a different way of saying the same thing? I think when we all think of due process of law, we think about the idea about procedure, about being able to appear in a court, being able to have a lawyer, being able to have a fair hearing. But it's been made clear that the Charter is more than just procedurally protective, saying that you have the right to certain ways in having your cases heard. It goes farther than that. It's substantive protections. It actually protects actual rights and not just the way in which the hearing is heard. So I would say it goes farther than just due process of law. The BC Motor Vehicles Act reference in 1985, again, a very early case on charter litigation, was a challenge to the law where someone could be imprisoned under the Highway Traffic Act where there was no defense available to them. If you were found to be the driver, you could be put in jail. And the Supreme Court of Canada said that's not fair. It's not just a procedural protection where you have a right to a certain type of hearing. They said this goes farther. It affects your life. This is a substantive protection. You can't put people in jail if there's no defense available to them, because that would infringe Section 7's right to life, liberty, and security of the person. In a case called Bedford, which was a case about the legality of prostitution in 2013, the Supreme Court talked about this. They said the motor vehicle reference recognized the principles of fundamental justice about the basic values underpinning our constitutional order. The Section 7 analysis concerned with capturing inherently bad laws. That is, laws that take away life, liberty, or security of the person in a way that runs afoul of our basic values. The principles of fundamental justice are an attempt to capture those values. So when they're talking about what is the purpose of Section 7, this is what they're describing. They're trying to capture inherently bad laws that are contrary to our basic values, in a sense that aren't fair. They give three specific examples in Bedford. One is arbitrariness, the second is overbreadth, and the third is gross disproportionality. And they really talk about those as being just different ways to capture bad laws. Arbitrariness means that there is no connection between the effect of a law and the purpose of a law. So you pass a law because you want to do one thing, and the effect is not that at all. So one example of a case that was arbitrary was Morgenthaler, a 1998 Supreme Court decision, which struck down essentially a ban on abortion in Canada. The law required that therapeutic abortions could only occur in accredited hospitals. And the stated purpose for that was it was to protect the health of women by making sure that these procedures were carried out in a hospital. The evidence that was led at trial showed that the law did the opposite, that in fact it harmed women's health because the procedure was too unduly restricted by having it only in hospitals. There simply weren't enough hospitals to service all of the women that needed the care. So by saying, no, this can be done outside the hospital, it opened up the procedure to occur in safe settings, but also make it more widely available and to promote health, because the law was actually doing the opposite of what it said it did. Another example is Canada and PHS from 2011. This is about the Insight safe injection site in Vancouver's downtown east side. This is a facility that allows people to inject drugs inside the facility so that if they have an adverse medical reaction, they overdose, their life can be saved. Because of the nature of that facility, they required an exemption from the federal government to operate, because what they were doing is contrary to the Controlled Drugs and Substances Act. The permit expired in 2008 and the Conservative government refused to renew the permit. The Supreme Court ruled that the denial of the permit in these circumstances was counter to the purpose of the legislation. The purpose of the CDSA is to promote public health and safety, and not renewing the permit was contradictory to what the purpose of the law was. Overbreadth is similar in that it's a law that targets a specific evil or purpose, but it goes farther than it needs to, and it sweeps up other people needlessly. So one example of that is a case called Haywood, 1994 Supreme Court of Canada. The law in question banned vagrants from parks in order to protect children from sexual predators. Quite a valid goal, and the law undoubtedly did that by banning vagrants from parks. The problem is that the law went much farther than it needed to for that purpose. It also banned people who weren't vagrants or sex offenders from parks, and it also banned vagrants from parks where children were not going to be present. So the law went much farther than it needed to, and when the law goes farther than it needs to and catches people that it should not, the courts will step in and say this is a bad law. Another example is a case called Safarzadeh Markali, 2016 Supreme Court of Canada. It was a law banning enhanced credit for time spent in jail waiting for trial. And the goal was to say, we want to target serious repeat offenders So anyone that's in jail because their bail was denied must be a serious repeat offender, and we're not going to give them enhanced credit for their time waiting for trial. The problem is that that caught a lot of people up. Some people who were denied bail ultimately got acquitted of the charges or the reasons why they were breached for their bail. Some bail breaches weren't serious. If you're homeless, you might just not have a place to live. And so just the fact that you're arrested because you don't have a place to live doesn't make you a serious repeat offender. And the Supreme Court simply said this law goes way too far in terms of it's poorly targeted at the serious repeat offenders, and it's catching up a lot of people who are not serious repeat offenders. And so that was struck down on the basis of overbreadth. Gross disproportionality doesn't come up too frequently. This is basically an example where the law is so severe that the law itself can't possibly be justified. And the classic example is that you want to have clean sidewalks in Winnipeg, and so you pass a law saying that you'll get a life sentence if you litter. Anyone caught littering will be put in prison for the rest of their lives, and by doing that, we'll have clean sidewalks. That might be very well true, but that is clearly so inhumane and unjust that no court, hopefully, would uphold a law like that. Section 7 can also be used beyond just attacking laws that I've talked about, can also be used to attack the treatment of an accused in any particular case. If an individual is treated harshly or unfairly by the government, that can be used to challenge their particular prosecution. So abuse of process is an example where you say the court system is being used in a fashion that is unfairly, that is undercutting the community's sense of fair play and decency. So the police arresting people to collect a civil debt, even though that they've never committed a criminal act, but these people owe money, so we're going to have them arrested so that they pay the person that they owe civilly. That would be an example of an abusive process. The prosecution using tactics to judge shop, to say, I want a particular judge, so I'm going to lay this prosecution in a community where I know there's only one judge and that judge is tough. Even though that's not where the crime occurred, that would be a form of judge shopping, which is unfair and would be an abusive process. Police fabricating evidence is a clear-cut example of a challenge to someone's life, liberty, and security of the person unfairly. Or an example is where the police do an illegal search, then they go to the courts and apply for a search warrant, knowing that the initial search was illegal. That would be an example. They're trying to cover up something that they did that was wrong. That would be an example of an abusive process. It can be used for lost evidence. If the police lose evidence, that can be a Section 7 challenge because you've now lost evidence that I would use to defend myself, and that's not fair. The Crown has an obligation to disclose all evidence in their possession to the defense so that the fair hearing can be fair, so you can have a fair trial. If the Crown holds back evidence, that would be an abusive process or a Section 7 breach. And judges can also, even in a trial, relax the rules of evidence in order to assist a defendant if it means that it's avoiding a wrongful conviction. So judges can even take steps in a trial to protect somebody's rights. I'm going to try and pick up the pace a little bit because I appreciate we're already at 12:42 and I want to leave at least a little bit of time for questions. Section 8, unreasonable search and seizure. Everyone has the right to be secure against unreasonable search and seizure. You can compare that with what the Bill of Rights has to say, the Fourth Amendment. The right of the people to be secure in their homes, in their purses, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And the United Declarations on Human Rights, Article 12, no one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence, nor to attacks upon his honor or reputation. Everyone has the right to the protection of the law against such interference or attacks. One classic example of unreasonable search and seizure in Section 8 is the Feeney decision, 1997, Supreme Court of Canada. On an early summer morning in 1991, the RCMP were investigating the homicide of Mr. Boyle in a very rural area of northern British Columbia. Mr. Boyle had been located in his residence. He had been very badly beaten in the head with an iron bar. It was a very bloody scene. And the witnesses described seeing Mr. Feeney that morning walking away from a car accident only 500 meters from the residence. So the police had a desire to speak with Mr. Feeney. He was residing in a what I would describe as a small, squalid, windowless trailer on a desolate wooded area on a compound. Another person who lived on that same compound spoke to the RCMP when they arrived that morning, said, "Oh yes, Mr. Feeney returned early this morning. He'd been drinking all night. He passed out in his trailer where he lives." And so the police attend to that trailer. They knock on the trailer, announce RCMP, "We'd like to speak with you." And there was no response. So the police then, as they are investigating a homicide, opened the door of the trailer with their guns drawn. They walked a few feet to the trailer bedroom. They shook Mr. Feeney awake, asked him to stand up. He was covered in blood stains, and they immediately arrested him on suspicion of murder. Were these constitutional actions by the police? The police were obviously investigating a very serious homicide. Time might be of the essence. There may be evidence that they need to preserve. There might be concerns about public safety if Mr. Feeney is a danger. But on the other hand, everyone is protected against unreasonable search and seizure. He was in a trailer which was identified to them as his home. It doesn't matter whether you live in a trailer or a tent or a duplex or a bungalow or a mansion. Do you want to live in a country where the police can enter your home because they say it's important? Trust me, I have to come into your home right now. Under the law prior to the charter, while there was a very high level of privacy and protection in the home, that interest yielded to the detection of crime. And the quote used by the courts was, "A criminal is not immune in his own home." So has the charter changed anything? The court says, and I'll just read the highlights, "The increased protection of the privacy of the home in the era of the charter changes the analysis in favor of the former interest. In general, the privacy interest outweighs the interest of the police, and warrantless arrests in dwelling houses are prohibited. The purpose of the charter is to prevent unreasonable intrusions on privacy, not to sort them out from reasonable intrusions after the fact. I conclude that generally a warrant is required to make an arrest in a dwelling house." So the Supreme Court says the police are not allowed to just barge into a house because they're looking to investigate something serious or they want to make an arrest. They have to get a warrant to do that. And you can see from that quote, and I'll tell you that that's the running theme throughout unreasonable search and seizure case law, is that the purpose of Section 8 is to protect people and to protect privacy from government intrusion. It does not protect places or things. We don't say the police can't go in cars. We don't say the police can't look for computers or things like that. We don't delineate it by the type of object. We are protecting people, and the context may change. As I say, it might be a tent has a privacy interest. It might be the phone in your pocket has a privacy interest. These are going to change with time and with technology. So you have this large and liberal interpretation. So when we have school searches by police, when you have sniffer dogs, when you have radar and heat imaging searches of suspected drug trafficking homes, these are all different situations in which the court can use that purposive analysis to say, does this contradict the purpose of Section 8? Is the government allowed to do this? Another example is the Mann decision, 2004 decision of the Supreme Court of Canada. Came from Winnipeg. Mr. Mann was walking down a frozen Winnipeg street in the middle of winter around midnight. Winnipeg police cruiser pulls up to investigate a complaint of a break and enter. They had a specific name of an individual that they were looking for, but Mr. Mann matched the description. The police officer said it was to a T. It was the exact same description. Approximately 21 years old, 5'8", 165 pounds, wearing a black jacket with white sleeves. When the police came up to Mr. Mann, They asked him for his name. They were checking his ID to confirm that he was not the same person that they were looking for, that it wasn't the same person giving a false name. While the police were waiting for that name confirmation to come back, they patted him down for officer safety. They said, we want to make sure that he doesn't have a weapon, that he's not going to harm us. Police felt a soft package in his clothing. The officer reached into Mr. Mann's pocket, pulled out a small bag of marijuana, less than an ounce. And Mr. Mann was arrested for possession of marijuana, even though he was right. He had nothing to do with the break and enter. He was just in the wrong place in the wrong time. And the police decided to pat him down for officer safety. Once again, the Supreme Court is called upon to do balancing exercise because policing is an inherently dangerous job. People carry guns, knives, all sorts of weapons, tasers. Are the police not allowed to pat a person down to protect themselves when they're potentially dealing with violent criminals? But on the other hand, if you're walking up the street, do you want to live in a place where the police can start going through your bag, start going through your clothing, because they're suspicious of you, even though there's no proof that you've done anything wrong? Justice Ayakubuchi writes for the court exactly that he has to balance individual liberty, rights, and privacy interests against or with a societal interest in effective policing. Absent a law to the contrary, individuals are free to do as they please. By contrast, the police may act only to the extent that they are empowered to do so by law. The vibrancy of a democracy is apparent by how wisely it navigates through those critical junctures where state action intersects with and threatens to impinge upon civil liberties. Nowhere do these interests collide more frequently than in the area of criminal investigation. Charter rights do not exist in a vacuum. They are animated at virtually every stage of police action. Given their mandate to investigate crime and keep the peace, police officers must be empowered to respond quickly, effectively, and flexibly to the diversity of encounters experienced daily on the front lines of policing. And he goes on to talk about investigative detention. But what he says with respect to the pat-down search, police may, in some circumstances, have the power to conduct a pat-down search incident to an investigative detention. Such a search power does not exist as a matter of course. The officer must believe on reasonable grounds that his or her own safety or the safety of others is at risk. They do not have a blanket right to pat down and search you for weapons at all times in all situations. Likewise, it doesn't justify the police to empty your pockets. They can, if they feel something soft, presumably that would not be a weapon and they wouldn't be allowed to reach in your pocket and grab it. The police are not allowed to do pat-down searches for as a way to conduct a fishing expedition to see whether maybe you got something on you. Police can only arrest you if they have reasonable probable grounds to believe that a person has committed a crime. They can detain you for further investigation if they have a reasonable suspicion that you're involved in offense. So much like Mr. Mann, the fact that he fit the exact description of the person they were looking for allowed them to detain him for further investigation to see whether or not there was anything else that they needed to be concerned about. But they could not gather any further incriminating information from him. I'm going to whip through section 9. Everyone has the right not to be arbitrarily detained or imposed. No one shall be subjected to arbitrary arrest, detention, or exile, is the United Declarations on Human Rights. And the Bill of Rights, 1960, no law of Canada shall be construed or applied so as to authorize or effect the arbitrary detention, imprisonment, or exile of any person. The Grant decision from 2009 Supreme Court of Canada is an example of arbitrary detention. 3 police officers are patrolling near a school with a history of assaults, robberies, and drug offenses, and they have 2 police officers in plain clothes driving an unmarked cruiser car. They're teamed with an officer who is uniformed, wearing a sidearm, driving a marked police car. The accused was a young black man walking down the sidewalk. The 2 police officers in plain clothes drove past. The accused stared at them. Mr. Grant, this young black man, stared at the 2 officers. He was fidgeting with his coat and pants. The police got suspicious. They asked the uniformed officer to discuss with him to see if there was anything to be concerned about. The uniformed officer stood in front of him on the sidewalk, blocking his path, asked him what was going on, asked his name and address. Mr. Grant was acting nervously, playing with his jacket, and the police officer said, "Please keep your hands in front of you." After a brief period of observing this, the two plainclothes police officers then get out of the car, come to the sidewalk, stand behind the uniformed officer, flash their badges, again blocking Mr. Grant's path. The uniformed officer then said, "Do you have anything you shouldn't have?" He says, "I have a small bag of weed and a handgun." The police arrested Mr. Grant, searched him, took the marijuana. Now, the question is this right? Is this just? Is this fair? Mr. Grant was never arrested by the police. He was never placed in handcuffs. The police never touched him. They were only having a discussion. He volunteered. Nobody forced him to say he had the handgun. So was he detained for the purpose in an arbitrary fashion? The Supreme Court says detention means, and again, this purpose of analysis, suspension of an individual's liberty interest by significant physical or psychological restraint. So the police don't have to lay hands on you. It can be psychological. Either the person has a legal obligation to comply with a restrictive request, for instance, you're under arrest, or a reasonable person would conclude by reason of the state conduct that he or she had no choice but to comply. So when you put that in the context of Mr. Grant, do we honestly believe that an 18 or 19-year-old black man in a police neighborhood who has three officers flashing their badges and directing him to show them their hands, that he felt he had any other choice but to answer their questions? The Supreme Court says in those situations, looking at contextual analysis, you can make the determination that the person is detained, even without them being physically detained. It can be a psychological detention, standing alone. I see that we're at 5 minutes to 1. So that might be about as far as I can make it. I don't know that I'm going to get to section 10B, which is really pretty straightforward, but I think I will stop it there for the moment and see what kind of questions there might be in the Q&A or the chat.